Hello, everyone. We have a special guest today, Steve Barron, attorney and partner at Barron Harris Healy. Steve concentrates his practice in four areas. One, intellectual property counseling, dispute resolution, and litigation involving copyrights, trademarks, trade dress, and trade secrets. Number two, media and entertainment law, including counseling and litigation relating to defamation and privacy. Number three, advertising and marketing law, including sweepstakes and contests. And finally, class action defense. Steve has counseled and represented clients on website accessibility under the Americans with Disabilities Act. Today, we're going to talk to Steve about ADA website compliance. Who needs to be compliant? And what do you do if you get a demand letter or you get sued for not being in compliance? Steve, how are you doing today?
I'm great, Ken. Thank you very much for having me on to talk about this important topic.
Well, thank you so much for being here as well. So I guess we get right to the questions. What websites must be accessible under the ADA?
Okay, I'm happy to answer that. And maybe just by a quick background, when the ADA, the Americans with Disabilities Act, was passed as a federal law, it was in the early 90s, around 1990, 91. And that was long before the web had exploded in the way it exists today. So websites were not mentioned in the ADA and to this day are not mentioned. But it's safe to say that the law has emerged and developed so that websites are increasingly being held to account to make sure they are accessible by people with disabilities. And in terms of what websites, there are some differences across the country about whether certain websites need to have a nexus or a connection to a physical place of business or not. But I think the safe approach would be to assume that all websites that offer goods or services for sale must comply with the ADA and have accessibility available to people with disabilities.
That makes sense. What constitutes an accessible website?
Yeah, so that's a good question. I think that the two key areas where the law has mostly emerged, although not exclusively, are people with sight disabilities, blind people or people with other seeing disabilities, and people with hearing disabilities. But there are other kinds of disabilities as well, for example, epilepsy and mobility issues. But let's focus for a moment on the blind and the deaf, since those are the most common ones. For blind people, a website must be accessible to a screen reader. So if you think about it, blind people use technology that allows them to turn a website from a text into speech. So it must be screen reader compatible and have alternative text for images and properly labeled fields and proper use of headings and keyboard only access, and of course, audio descriptions for videos. Where there is somebody with lower vision, maybe some vision, but low vision, you have to have good color contrast and the ability to resize text. And then for people that are deaf or have hearing challenges, the main issue there is having captions for audio content, so closed captioning essentially. And then on mobility, you need keyboard access, keyboard only access. And for epilepsy, you need to make sure that you don't have flashing content. And then finally, for colorblind people, you want to make sure that color is the only method of conveying information on the website. So that's a quick sort of thumbnail sketch. It's more complicated than that, as you know, but that kind of gives you a sense of the kinds of issues that disabled people face.
Very interesting there. So, a lot of times when you go and you research this, you're looking for ADA guidelines and you keep getting referred back to the Web Content Accessibility Guidelines, WCAG. So why is that? And what is WCAG? What is that? Can you explain that for me?
Yeah, sure. So the Web Content Accessibility Guidelines, WCAG or WCAG or however you want to pronounce it, are not law per se. They're not passed by the government or by Congress or by any state. In fact, they are promulgated by an international consortium called the World Wide Web Consortium, or W3C. And W3C essentially has filled a gap that legislatures in this country and in fact around the world have let fall through the cracks. And that is, what does it take to make a website accessible? And so even though they do not have the force of a governmental mandate, they have become, in essence, the de facto guidelines that courts look to in this country for guidance on web accessibility. So the WCAG, or Web Content Accessibility Guidelines, have become the go-to guidelines, even though they are not passed by Congress or other legislative body. They're not a legal standard, but they have become a sort of de facto set of guidelines that most all website accessibility experts look to. And I assume that goes for you at Scalesology. Is that correct?
That is absolutely correct. Yeah, that's our guidelines as well. We go by the Web Content Accessibility Guidelines, and the gold standard, I think, right now is still level 2.1, or excuse me, section 2 or 2.1 level AA is kind of what
that's
we're
right.
having as our gold standard at this point. Well, we talk about guidance though a little bit. Has the Department of Justice under President Biden issued any updates on guidance?
Yeah, that's a fair question. And maybe just by way of background, to elaborate a little bit further on your question, as well as sort of how we got where we are today. As I mentioned, at the time the ADA was passed in the early 90s, web accessibility was not even contemplated. And so it's emerged as an issue. And Congress has variously attempted to deal with this, not directly, but through the Department of Justice, which is the administrative agency that deals with promulgating guidelines for such things. And the Department of Justice, the DOJ, has really not been able to promulgate guidelines over the past many years, spanning now decades. There was some effort during the Obama administration. Following that, during the Trump era, obviously the Trump administration was, frowned upon regulation, and so they didn't advance the ball. But now the Biden administration has taken up the mantle, and just last month in March, the DOJ issued what they call their web accessibility guidance for state and local governments under the ADA. But frankly, there isn't a whole lot new there. The Justice Department has not issued its own guidelines or promulgated any kind of specific rules. They've just said things that I think everybody already knows. And we are still, in essence, relying upon the WCAG or WCAG guidelines that we talked about a moment ago.
Well, to me, it's always a good practice to make sure that everyone can see your website, which is why I think, being ADA website compliance is such an important thing. But what about lawsuits? Are there lawsuits being filed because websites are not in compliance?
Absolutely. In fact, over the last several years, it's been an enormous growth industry in the federal courts. And just to give you a frame of reference, last year in 2021, there were 2,895 federal lawsuits filed.
Wow.
And when I say federal lawsuits, these are lawsuits in the federal courts filed under the ADA. And that doesn't even include state court actions that are filed in the various state courts around the country. Last year's numbers in the federal court were an increase of over 14% from 2020. So this is a growth industry for plaintiffs, lawyers in particular. And one of the things you should know, and I wanted to make clear, is that the ADA, as of statute, does not allow for monetary damages. That is to say, if you're a blind person or a deaf person and you sue under the ADA, you're not entitled to damages. You're only entitled to injunctive relief, which is, in effect, a court order that would allow, require the website to become compliant. So why all this litigation if there's no money involved? Well, the answer is the ADA does allow for attorney's fees. So guess who wants to get in on that action? Yes. Yeah, the attorneys, of course, the plaintiff's attorneys are very active in this area. And I will tell you that in order of frequency, New York tops the list in terms of the number of cases filed in federal courts. California follows behind, and then the third is Florida. Illinois, where we are, is probably in the top 5 or 6, just so you know. But yes, there are a ton of lawsuits, and it seems to be a growth industry right now.
So if you're a business owner or a head of a division or someone who's in charge of your company's website, I mean, what should you do to like mitigate that risk?
Yeah, so I think I would recommend a couple of things. Number one, I would recommend, of course, hiring a competent website accessibility expert such as Scalesology to come in and assess where a website may have issues or problems. And you can speak to this obviously in a more concrete way than I can, but competent web experts in this area will do both automatic algorithmic testing through software, and then they'll do also some manual testing or human testing as well. And they will check on these issues that I alluded to earlier. Is it screen reader accessible? Closed captioning? And are other issues on your site okay? And once you get that and you mitigate whatever issues come up in that kind of an assessment, a lot of companies, and I'm sure Scalesology is one of them, will allow you to use essentially a badge, if you will, that says, this site has been checked by so-and-so, in this case, let's say Scalesology. And that badge can become a bit of a deterrent for, plaintiffs' lawyers that are looking for websites. So it's good to have that testing done to mitigate the problems if they exist, and then to put that badge up on your website. And the second thing I'll say is, check, if you're a business in particular, check your insurance coverage to see if you were to get sued, do you have insurance coverage for such a claim?
That's a really good point. And I'm happy to say at Scalesology, we do a manual and an automated test with our process. And our goal is to have our reports copyrighted, and the goal is to make sure that it's showing all the different ways that you're not in compliance, and more importantly, how to fix those. And so, and that's really important. So, but what if we're at some point you didn't do an audit, you don't know if your website's ready to go, and all of a sudden you get a demand letter. And what should you do as a company? Sure.
And I've had clients, ignore these things, bury them, throw them in the so-called circular file. I don't recommend that. I think you need to take it seriously. These are not necessarily trolls, although it feels that way. I think if you get a demand letter, you should take it to a lawyer who knows what they're talking about in this area, and also, of course, to an ADA website accessibility expert firm such as Scalesology to do some testing to see if there's any legitimacy to the issues raised in the demand letter. And, if you can run a test and show that the website really is largely accessible, and, it doesn't, and that's an interesting question too, right? Which is, does it have to be perfect? No, a website doesn't have to be perfect. The law really talks about reasonable accommodation, right? You have to make reasonable accommodation. So you want your pages to be, generally speaking, in good shape. But I would say once you get your background done with communicating with a lawyer, as well as communicating with an ADA accessibility expert, and then you can have your lawyer draft a letter back and hopefully be able to represent that you have taken steps and everything is in good shape. Or then, you negotiate a potential resolution pre-litigation. And most of the time, plaintiffs' lawyers are looking for a quick resolution and settlement, payment of some amount of money, relatively modest, particularly pre-suit, and they will give you a period of time to bring your site into compliance.
All right, that makes sense. So there's a roadmap. Now, what if I was bad, Steve, and I ignored those demand letters, and then I'm now sued? Is there different steps, or what should we do under those circumstances?
Right. It's not terribly different from just the demand letter, but now you're in a formal proceeding, and so now you've got to deal with it or face the potential for a default, and you don't want that to happen. So at that point, you have to get counsel. I would say, as I mentioned a moment ago, check your insurance, because increasingly insurance companies under general commercial liability and sometimes under employer liability policies, believe it or not, provide some amount of coverage for these kinds of cases. So you want to tender it to your carrier and see if you have any coverage so that you can at least mitigate any expense you have. And then, in most of my experiences defending cases in this area, the plaintiffs really want to settle, and they want to settle as quickly as possible. And so typically you can negotiate a settlement that will involve potentially some payment of money, although not astronomical, and an agreement that you will become compliant, meaning that you will bring the website up to WCAG 2.1 AA within a period of time. And oftentimes that period of time is anywhere from 12 to 24 months. So it gives you some, extended period. Assuming you can reach an agreement about that, you will then enter into a settlement agreement, and the case presumably will be dismissed. And of course, at that point, you want to make sure you then comply with the provisions of the settlement agreement that require you to bring the site up to compliance. But most of these cases really do resolve quickly, and they should. So I would not, I guess, my point in all of this is, don't dig in your heels here. You're not going to get very far, presumably, in protracted litigation over accessibility to your website.
That makes sense. Steve, I just want to thank you so much for being a part of this conversation today. We're running out of time, but if someone has some legal issues, how do they contact you? What's the best way to contact you?
Sure. So again, my name is Steve Barron. My law firm here in Chicago is Barron Harris Healy, and my email address is sbarron, SBARON, at bhhlawfirm.com, and my telephone number directly is 312-741-1027. Always happy to chat.
Excellent. Thank you, Steve. And the accessibility expert is talking about Scalesology. If you need to contact us, please do at www.scalesology.com. Our phone number is 312-809-3996. Again, my name is Ken Scales, or you can email me directly, ken.scales@scalesology.com. Steve, thank you so much for being a part of this today. And I will be talking to you more soon.
Excellent. Thanks for having me. Take care.
Thank you.